Hi, everybody. Mitch Tabbam here. Thanks for joining me today. Today, I'm going to talk about a new proposed government cybersecurity rule. This is one we've been waiting for literally a year, and it applies to all civilian executive branch contracts, which is basically everything other than the DoD. So the issue here is something called Controlled Unclassified Information, a term which was created back in like 2010 or 2011 under Executive Order 13556, which is sensitive information basically that we don't want to share with the Chinese or North Koreans or Russians or whatever. There is a federal acquisition regulation known as a FAR, which has been around for, well, before that time, actually. Called 52.204-21, and that is for the protection of all data, really all data. And it's very lightweight. It's got like 15 requirements, and they're very minimal. The FAR Council, which is the group of bureaucrats that works on creating these regulations, which is collectively known as the FAR, the Federal Acquisition Regulation, which is made up of folks from NASA, DoD, and the GSA, has been working for years, like 4 or 5 years, on updating this particular FAR rule. And finally, this week, they put out a draft, which is up for a 60-day comment period, and then they have to go review the comments, and then they republish it, and on and on. That process typically takes about a year. So this is just a draft. But this will apply to all government contracts that contain data. The only exception to this, well, there's two exceptions. One is what's called commercial off-the-shelf stuff. And COTS actually stands for software, but it's really stuff. So if you're selling something to the government that anybody can buy, and the government is not changing it, let's say it's a box of tissues, right? Now, the government doesn't want a box of tissues that has, their special whatever, and they're not using regular tissues, but it's got to have an extra ingredient because it's the government. That's not COTS. But if it's the same box of tissues that you could buy at the grocery store, that's COTS. That's excluded. The other thing that's excluded is federally funded basic and applied research, which is not specifically tailored to solving a particular government problem. So you got some, person at the university that's doing basic research, and maybe when the research is done, the government will say, "Hey, this applies to us. That's fine." But in the meantime, that is not. This rule does not apply to that. So, next note, there's a simplified acquisition rule for contracts below $250,000, and a lot of rules typically do not apply to those what the government considers small dollar value contracts. This is not one of those things. This applies even to those things below the simplified acquisition threshold. So that's important to understand. Also, and this is great, and this actually applies even to defense contractors, there is going to be a new government standard form, which has a placeholder number of SF for standard form XXX, which they always do until the rule is finalized. And it's like long, and it has all the information you know about the data that's in there and what applies and how it needs to be protected and all this stuff. The form itself is 14 pages long, and it has all the stuff that you need to worry about in terms of what's in the contract. And I'm going pretty quickly here because I'm trying to cover this in an amount of time that you're not going to get bored and leave. Um, at least as this regulation applies now, there is no phase rollout, unlike what the DoD is doing, which is actually, they call it a 4-year rollout. It's really a 7-year rollout. This is going to be, they flip the switch and it's there. That doesn't mean that the individual agencies might not implement some kind of phased rollout, but we just don't know what that looks like yet. There's going to be 2 standard contract clauses. They also have placeholder numbers, 52.204.XX and 52.204.YY. The first one is for contracts that have controlled unclassified information, and there's a whole but what's considered controlled unclassified information. That's a whole conversation by itself. But there's a lot of stuff. It's like 100 different categories of controlled unclassified information, and then the YY clause is for contracts that don't have controlled unclassified information. In the YY clause, it says that contractors are required to notify the government within 8 hours if they identify something in the contract that's either provided to them by the customer, typically, which is either incorrectly marked, or since this contract is not supposed to have any CUI, is marked as CUI. You have 8 hours to tell the government about it. And it doesn't mean that you have to do anything special to protect it. The government will deal with that, after you tell them in 8 hours. But that's not a really big window. So under that first clause, under the XX clause, it says that you're only required to protect what is defined in that standard form at the end of the regulation. It talks about your reporting obligations under this. If you have control of classified information, you also are required to report within 8 hours. That includes mismarked information, stuff that is not CUI, that's marked, that should be marked, or stuff that is marked that isn't CUI. It talks about your training requirements. It talks about your compliance requirements with 800-171 revision 2, which is the same version of 800-171 that the DoD is using for theirs. It talks about 800-172, which is kind of an upgraded version of 800-171, and they say that's really only going to apply to literally a handful of companies. We don't believe that, but still, it's going to be a relatively small number. Next, and this is really important, if you use cloud software, that cloud software must be FedRAMP authorized. That's a whole can of worms. It's expensive to get stuff FedRAMP authorized. It's time consuming. There are very few cloud software products that are FedRAMP authorized. So that's a problem if you use cloud software. Unlike the DoD, where you're required to potentially submit to, a $50,000 third-party certification program, that's not required here. What it says is you have to have a system security plan, which is the same thing that's required for the defense contractors, and a plan of action and milestones, and you must submit that to your agency customer on request. And the agency may choose to conduct its own assessment at their cost and your pain, using NIST SP 800-171A or NIST 800-172A, depending on the particular contract. So good news is you don't have to pay for it. Bad news is you still get to deal with the pain. The training requirements are in this standard form also, and I'm getting close to the end of my notes, so this will be over soon. For reporting incidences where you have a spill of controlled unclassified information, you're going to get to use the same or collect the same information. It's probably going to be a different form, but you get the same information collected that a defense contractor is required to report using a DIBNet, a DoD mill. So they're at least leveraging some of the things that DoD learned over the last 10 years. If a contractor is deemed to be at fault, they get to potentially pay the government for the government's costs for dealing with a breach and the damages as a result. We're already seeing this on the DoD side. And this is like a lot of government federal acquisition regulations. This is a mandatory flow down to subs, including this SF standard form XXX. That has to be flowed down, and you can modify that to the extent that it's not applicable to the sub, but nothing more than that. And if the sub has a breach or you have a breach, then they need to notify the next food level, up in the food chain. So, if you're a sub, and maybe that is your prime, and if you're a sub to a sub, then that's going to be, your next level up. Next is the cost. Their estimate, assuming you've done nothing, their estimate for a small company is about $175,000, and for a large company, about $680,000. This is the most reasonable number I've seen in terms of accuracy. We've seen a lot of numbers which really underestimate the cost. This is expensive, and figure about 20% of that on an annual basis. If you have to implement 800-172, which they say is going to be a lot less companies, that's an additional $200,000 for small companies, $1 million for medium-sized companies, $2.3 million for large companies. Again, 20% of that on an annual basis for maintenance. So big numbers, but hopefully you sell enough stuff into the government that you can make up for that. If you are doing things that have an overhead calculation, then you'll have that. And, people have said, well, how do I stay competitive? Hopefully everybody's going to comply with this, and agencies are going to start asking their contractors for copies of their system security plan. If it comes back as bogus, then they can't award the contract. So this process will likely take a year, maybe more, maybe 18 months. So this is not something that's happening today. And I suspect that they will amend this to come up with some phased rollout, because that's the only way it can work. But it's not in there right now. And as I said, this applies to all what they call federal government, civilian, executive branch agencies, which is everybody, other than the Congress and the judiciary and the DOD. And they've done this in a way that's designed to try to harmonize this with what DOD has done, because what DOD has done is not going away. If you sell to both, non-DOD agencies and DOD agencies, there's a huge amount of overlap between the two. So that's pretty good and not going to be a big problem. If this scares the bejeebers out of you, it probably should. If this is the first you're hearing of it, it probably should scare the bejeebers out of you. If you need help, that's what we do for a living. Please contact us. If you need a copy of the proposed regulation or the standard form or any of that, please contact us as well. While technically you can do this by yourself, there is no requirement that you hire a company like us to do this. It's highly unlikely you'll be successful unless you have an incredible amount of IT support inside your organization. So with that, I'm sorry to ruin your day, but please reach out to us if we can help. Take care and stay safe.